But today we are going to focus at the start on Disha Ravi. That's right, the 22-year-old activist who got bail, remember yesterday, is finally out of jail today. A day after she was granted bail by a Delhi court, she has stayed back in the capital and not gone back to her home in Bengaluru. Disha's parents have welcomed the bail order. So interestingly has the opposition, even as the government remains silent. It's our top story today.
Disha Ravi, the young climate activist from Bengaluru, finally walks free. She was released hours after a Delhi court granted bail on Tuesday in a case related to farmers' protest Toolkit she shared with climate activist Greta Thunberg. The day after, Disha stayed away from the flashbulbs in Delhi. Her family is relieved. Disha's father reiterated she had done no wrong.
Justice has been done, aste sir, aste ಏನೇನಿಲ್ಲ. We have not done anything wrong. That's the only thing, sir. Aste. We are not connected with any this thing. We are just asking this basic question.
The bail order by Additional Sessions Judge Dharmendra Rana ripped into the Delhi police. The court said that the creation of a toolkit is not an offence. The order states there is no call for violence in the toolkit Disha shared with Thunberg. It noted that there is no proof she subscribed to any secessionist idea. The judge found the evidence on record scanty and sketchy, saying it isn't enough to keep a 22-year-old under custody. The opposition has welcomed Disha's release.
जज साहब ने सही कहा कि जो विरोध करता है जब तक उसके खिलाफ कोई ऐसा ठोस सबूत न हो, जब तक ऐसी बात सामने न आए, तो वो सेडिशन का केस उसको या तो बेल दो या ऐसे केस उसके ऊपर थोपने नहीं चाहिए।
अच्छी बात है कि जमानत मिली, बहुत लेट मिली है, लेकिन ये केस केवल जमानत वाली नहीं है, ये केस इतना झूठा बनाया हुआ केस है, इसको वापस ही लेना चाहिए।
The lower court order could set a new landmark. It seems to reaffirm the legal doctrine, bail is the rule, jail an exception. But it remains to be seen if other courts also take a similar view in cases that involve activists. With Anisha Mathur in Delhi, Bureau Report, India Today.
Today we are going to be joined by some of the country's top lawyers, judges, police officers on that big question. Bail, not jail. Has the time come to reaffirm that principle? The big question, is this Disha bail order by a sessions court judge in Delhi a landmark? Is bail, not jail, the doctrine that has been reaffirmed? Will other courts take the same stand given the number of people who are still under trials or indeed have been jailed without a charge sheet over the last few years? I'm joined first by the former Attorney General Mukul Rohatgi. He was Attorney General till not too long ago. Appreciate your joining us. Mr. Rohatgi, do you see this order as reaffirming that principle, bail is a rule, jail is an exception? Do you believe that this order could set a precedent for other cases where people have been arrested in contentious circumstances on the charge of sedition?
I do, and I am very happy that a courageous and a bold judgment has come from a district court, not the Supreme Court. And full marks to the judgment and the court for keeping the flag of liberty flying. And as you said, Rajdeep, this famous adage, bail and not jail is the rule, was stated by one of our finest judges of the Supreme Court, Justice Krishna Iyer.
You know, but the reality, Mr. Rohatgi, sorry to intervene, is that, you know, a study, study by a lawyer, Abhinav Sekhri, shows 28% get bail only after spending 6 months in jail, 14% spend between 1 and 3 years in jail, and since 1980, the under trial ratio hasn't dropped below 60%. So, is this an exceptional case because of the media publicity? What happens to the average person?
See, I don't want to comment whether it was an exceptional case because of media coverage, etc. But the fact of the case is, and I did say about 10 days ago in another discussion, that a charge of sedition is a very, very grave charge. It was a charge which was framed by colonial powers when India was not independent. And the idea was to keep the local populace under threat, that if you do something like this, you will have transportation for life, which was called Kala Pani and now is called life imprisonment. It was meant to be a call to violence to overthrow a legal government or a lawful government.
Yes. But,
To
sir,
have disaffection against the government, insurrection against the government. That's
Yes.
the nature of the charge. Now, in this case, there was no material whatsoever anywhere near that kind of a charge. That's one. But I want to tell you, if I can tell your viewers in about 2 minutes,
yes,
one of the fundamentals of our constitution is presumption of innocence. That you have to be proved guilty by the prosecution, not that you have to prove your innocence. The two most cherished fundamental rights under the constitution are the rights of life and liberty and the right of freedom of speech.
yes.
Now, slowly and slowly, since the 1980s and 90s and 2000s and so on and so forth, this rule of presumption of innocence was changed. Firstly, it was changed in terrorist cases. It was accepted by the Supreme Court. In a terrorist case, security of the nation is at stake, so all right. But slowly and slowly over the years, I find that in the last 10 years, this rule of presumption of innocence has been given a complete go-by in offences as petty as a violation of the GST Act. Can you believe it that the GST Act has a maximum sentence in a case, if you violate the GST law, 5 years is the maximum sentence. Even in a case of 5 years, the presumption of innocence has been taken away. You have to show to the judge that you are prima facie innocent, and then only you will get bail. I have done cases under GST. I have done cases under GST laws, people who are imprisoned. They spend 6 months to 1 year in jail. Now, if the maximum is 5 years and the man is going to be acquitted because the rate of conviction is not more than 50%, who is going to recompense what he has lost in jail as an under trial?
Sir, I understand. Sir, you are right, but I want to understand why does it take a lower court judge, for example, to make the statements that he did, that citizens cannot be put behind bars simply because they choose to disagree with state policies? Because the reality is, and this stretches back to UPA in 2010, but has intensified in the Modi government, where 65% of nearly 11,000 individuals in 816 sedition cases have been implicated since the Modi government took office. Opposition politicians, students, journalists, authors, academics. The point is, you were an attorney general, dare I say, in that government. What we are seeing, it started with the UPA in 2010, it's intensified to 2014. You criticize the government, you get implicated. 96% of sedition cases filed against 405 Indians in the last decade are for making critical and derogatory remarks against governments. So something seems to be wrong, sir.
No, Rajdeep. I don't want to get involved in the UPA government or the second government, etc. But what I find is that it is a trigger-happy police, that you put on or paste such serious offences in an FIR, whether sedition or a murder charge or a charge of attempt to murder, which are punishable with 10 years or more. The moment you do that, the judge generally takes a back seat and does not grant bail as soon as it should have been granted.
No, so are you blaming trigger-happy policemen? Are you blaming the policemen for being trigger-happy?
See, it is the police which creates the FIR, not the government. It's the police which writes an FIR. And let me tell you, in simple cases which are punishable with, say, up to 5 years, if the police is trigger-happy, it will put in a section or 2 sections which will take you to 10 years. And the moment that happens, the entire jurisprudence changes and the judge feels, oh, it's a very, very serious offense. It may not be.
So the police takes instructions from political masters. With due regard, the police takes its instructions from their political masters in many instances.
I don't want to enter that debate whether they do or they don't, but let me tell you, forget these kind of cases that you're talking about. I'm talking about run-of-the-mill cases. In run-of-the-mill cases, in a car accident case, you will have an offense of attempt to murder. Can you believe it? In a car accident case, is there a motivated desire to kill somebody in a car accident case? This is all actions of the police. And let me tell you now, it is a courageous judgment by a district judge. And if I may say so with great respect to our judiciary, the High Court and the Supreme Court have been lagging on this front. They have allowed this kind of non-grant of bail to kind of become a punishment. Arey chalta hai, let somebody be in for 30 days, 60 days, 90 days. Let him get a taste of the medicine because 50% they're going to be acquitted. And yesterday I read a report of a comment of the Supreme Court yesterday in one of the cases in which I had appeared, that this now seems to be the rule. And you allow a person to have some taste of punishment as an under trial, which is completely illegal.
You're making a very important point as a former Attorney General. You're saying the high courts and the Supreme Courts of the country are more reluctant to give bail than the lower courts, and the district court, in a sense, has set an example for other courts to follow.
I have no doubt about it. And let me tell you, 40 years ago, when I started practice, or more than 40 years ago, bail was argued for 5 minutes in a court, and the bail order would be half a page or 1 page. Today, in the High Courts and the Supreme Court, the bail petition is argued and opposed for hours together, and the orders are 10, 20, 30, 50 pages. I mean, that was never the concept of bail. The bail was only to be refused on 2 or 3 grounds. Namely, will the man run away or flee from justice? 2, will he tamper with the evidence? 3, will he threaten witnesses? That was the 3 grounds on which you deny bail, because the accusation is yet to be proved. Now today, you have upturned the concept of presumption of innocence. Now in a GST case, the presumption of innocence has been upturned. Can you believe it?
So you are telling me today that what the additional sessions judge Dharmendra Rana said yesterday, the rest of the court should look at and follow tomorrow. Am I correct?
Absolutely correct. He has kept the flag flying. In fact, higher courts should learn from this and come back to what Justice Krishna Iyer said in 1978. That is still the law.
Okay.
It's not that it's just been buried. It's just been buried now over the last few years. And we have forgotten what jurisprudence, criminal jurisprudence, if you ask me, in one line, has been turned on its head. Please mark 2 important things. 69% of people in jail are under trials. Some for petty offences, some for bigger offences. And every day in the Supreme Court, I appear in cases where people have put 10 to 15 years or 8 years, some cases where 7, 8 years have been spent even as an under trial. Now, if the man is going to be acquitted after 10 years and he has spent 8 years or 9 years, will the state ever recompense a person of having lost 8 years of his life? There is no recompense in this country, as you have in the US.
Okay.
So it all goes on. And let me tell you one more thing finally. That we accuse bureaucrats of just pushing files and passing the buck. Now the same thing is happening in the judiciary. I mean, the first court generally says, I'm not going to grant bail, you go up, go higher. Go to the district judge. District judge would say, go up, go to the Supreme Court, High Court, go where you want. I'm not going to grant you bail tomorrow. You must spend some time. So this is the mindset now, spend some time. Time will vary 1 month to 5 years, given the nature of cases.
You have been extremely candid. You have been extremely candid, Mr. Rohatgi, and I hope that someone out there is listening. I appreciate, though, you're joining us and giving us your perspective, because you have set the stage, in a sense, for my debate today. Because I'm joined now by a former justice, Deepak Gupta, former judge at the courts, at the high courts, Indira Jaising, former attorneys, additional solicitor general, Yashovardhan Azad, former IPS officer, joining me. But I want to come to you, Judge Deepak Gupta, first, because you might have heard what the Attorney General said. He said judges are either passing the buck, and in fact, the higher courts are more reluctant to give bail. It is the lower courts, a district additional session judge, Dharmendra Rana, in a sense, has set an example for higher courts. Do you agree that the Disha Ravi judgment or order could set a precedent for other judges to follow, sir?
No, I totally agree with what Mr. Mukul Rohatgi said. Absolutely. And I also would like to commend Mr. Dharmendra Rana on a very well-written judgment. It's not only the fact that he's granted bail to Disha Ravi, but if you read that 18 pages judgment, it reads so beautifully. It's like a piece of art. It's really commendable. And I don't think this can be cited as a precedent because he's not a higher court, he's a district judge. But it should give courage to other judges that we can also write judgments like this.
No,
It
but
should
why?
encourage
No, sir,
others.
but I'm sorry to intervene. Why is it that judges of the Supreme Court and High Court don't have the same courage that an additional sessions judge has? What does it say about our system?
No, it's not that it's not that the judges of the High Court or Supreme Court don't have the courage, but as this system has been building up in the last 10, 15 years, that we have this idea in our minds that our system, in our criminal justice system, most people, even the criminals, get acquitted. It may be true, but that doesn't mean that people who are under trials should be behind bars. Please remember what Mr. Rohatgi said, that almost 70% people in Indian jails are under trials. I was attending a webinar a few days back wherein it was said that in fact in bailable offences, remand is being given by the judicial magistrate. You see, they're not sensitive to because if we look at a constitutional scheme, Articles 21 and 22 of the Constitution, Article 21 says nobody can be deprived of his life or liberty except in accordance with law. And Article 22, probably this is one of the few articles which exists in very few constitutions in the world, which says within which time a person has to be produced before a magistrate, within which time, how much is the maximum time which a person can be detained, both in normal cases and in preventive detention cases. It sets out a constitutional scheme that jail is not the rule.
Sir, I take your point. I take your point, but I want to come back to the reality that exists on the ground. You're giving me first principles, and I respect that, sir. But Indira Jaising, do you believe there's something fundamentally wrong in our judicial system? That you've got now a former judge telling us, yes, there is a problem. You've got a former attorney general saying, yes, there is a problem. Disha Ravi's case, she spent 10 days in custody at the end of the day. The question therefore must arise, do we need to relook at entirely, of course, sedition, but also the basic principle of bail, not jail?
Oh yes, there is something very wrong with the criminal justice system.
What is wrong? What is wrong?
I wouldn't mind renaming it the criminal injustice system. It produces, it produces people who are thrown into prison sometimes for no crime at all. When it comes to the Supreme Court, many people have said, well, the district courts are better than the Supreme Court. Whether this is right or wrong, I cannot say. But I have often said there is more than one Supreme Court. And it's the luck of the draw before which judge your case would go, perhaps. That's one way of looking at it. But I'd like to make a more nuanced comment about this particular judgment in the case of Disha Ravi. I'm getting the impression that judges are waking up to the fact that law of sedition and UAPA is being abused in a routine manner. And it's become a pattern. And I would like to believe that that is the reason why this judgment has come. That's the link between lack of evidence or the evidence being flimsy and the grant of bail. But
we've got so many, sorry to intervene, we've got so many people, including some of whom you are appearing for, who've spent years in jail under UAPA. And UAPA's basic premise is to deny bail for the first 6 months. So you've got the likes of Sudha Bhardwaj, who've spent years now in jail. Again, many believe with very, very flimsy evidence. But UAPA, by its very nature, very few judges are willing to give bail. Varwar Rao only got bail, I think, yesterday after a long fight that you had.
Right. Rajdeep, you earlier brought on the question of how the UPA government has amended laws and now how the current government has amended laws. Let me tell you, there's a major problem with what are known as special laws. 3 examples. UAPA amended by the UPA in 2012 by making economic security a threat to the nation, which means any agitation on the issue of environment becomes a threat to the security of India. This was the UPA government. Let me come to the 2 other laws. NDPS. NDPS launched as a war against drugs. And the 3rd law, which I want to point to, is the PMLA. Prevention of Money Laundering Act. These three laws actually erode the basis of criminal justice because they say you presume a person to be guilty and let them prove their innocence. Now, if you want to know my opinion, unless these three laws are reversed, we are not going to see any criminal justice. First, re-establish the proposition that we are all innocent until proved guilty. Then
I take your point. I just want to though come to the police officer in a moment, because Yashovardhan Azad, I heard Mukul Rohatgi say today on the show that the police are trigger happy, that the police are more than inclined to file FIRs in sedition cases. Disha Ravi is one example that has got a lot of publicity, but I can give you many other examples in different parts of the country that often get lost because the police goes and files an FIR. It's often against tribal activists, for example, in Jharkhand. We've seen it in Tamil Nadu with Kudankulam, the anti-nuclear protesters. FIRs are filed under sedition and people remain in jail for years. Is the police the problem or is the judiciary the problem?
Well, apparently it's quite clear here that the entire criminal justice system is rotting. I mean, and it's quite clear that no one can do anything about it, except perhaps complain. I totally agree that in quite a few cases, the police institutes and puts up acts like sedition, which should not be there. But I can't comment on all the cases as to what is the truth behind it. But certainly, I would say that if there are 70% under trials in the prisons, I mean, why doesn't the judiciary grant them bail? I can understand the policemen can be trigger happy, but there are so many oversight mechanisms. And I'm glad that both the lawyers here commented that the judges need to be a little more forthright, a little more open. And in this respect,
but why is the police trigger happy? The police, many of these are IPS officers, presumably. Many of these are people who've gone through a training system. Why is the police? Is it that they are taking instructions from their political masters? Particularly in cases like Disha Ravi. Let's be honest. In cases like the Delhi riots, in cases of UAPA, of anti-CAA protests, because these are seen as anti-government, the government wants to send out a chilling effect message. Therefore, because the police believes that they must arrest people even without allowing the due process to be followed.
You realize, Rajdeep, that for a long time, the police reforms are on the anvil. And one of the biggest issues there is that the police autonomy in terms of registration of cases, etc., which should be there, and which is being practiced by all the bold officers, are certainly not being practiced by all of them.
Some police reforms have been thrown into, some police reforms should have been followed for the last decade and more. The political class doesn't do it, and police officers don't seem to be pushing for reform. What does one say?
No, not true. Not true at all. No, I don't agree with that. I don't agree with that. Even today, the police is crying and saying, please reform me. But it's the political class which doesn't want it to be reformed. Ask the lawyers and they would know that how many appeals are there pending all over. In fact, one of the Supreme Court justices, I think it was Mr. Thomas, who was reviewing the police reform, said that it is unfortunate that none of the states I have seen there is that kind of determination to do or enter into any kind of a police reforms. So while I totally agree with you that a certain percentage of the policemen buckle backwards and submit to the politicians, there are quite a few who have a firm firmament with them and they do not. And that's why there are cases like this which happen.
Okay, Justice Gupta, there is a sense one again gets that, as Indira Jaising is suggesting, there are laws that have been brought in by the political class, whether it's UAPA, whether it's NDPS, whether it's prevention of money laundering, that is reversing the basic premise of Krishna Iyer's judgment in 1977 that bail not jail is the way forward. Do you believe that's the problem, that these laws need to be reversed? Is it the interpretation of the laws that is the problem? Do you believe that reversing, let's say, Britain, for example, has just withdrawn sedition in 2009. Should India be doing that given the misuse of the law?
No, I am strongly of the belief that sedition law must be withdrawn. Because anybody
must be withdrawn.
Yeah, any criticism of a government is an essential part of democracy. It's necessary in a democracy. If there are two views and I hold another view, contrarian view to the government, somebody can't be sent behind bars just because of that. But coming to the other aspect of some laws where this whole, our basic criminal justice system is premised on the basis that every person is presumed to be innocent unless proved guilty. Now, what has happened over the last many years is that courts feel that people get acquitted Therefore, the only punishment which is going to be given is send them to jail or to send them behind bars for a few days while and not grant them bail, which I feel is totally contrary to the constitutional scheme of things. Bail, not jail, is the rule, and that is not only the essence of the constitution but also of the criminal procedure code, which envisages that every investigation should be completed within 24 hours. If you can't complete it, you go to a magistrate.
So why is it not, sir, sorry to again intervene, why is it happening? Kapil Sibal said yesterday, bail to Disha, heartening to note that while superior courts have chosen to wait and watch in matters of sedition, the subordinate judiciary has started questioning the misuse of sedition law. Now, I could extend that to UAPA, I could extend that to other laws. Do you believe, I'm going to ask you a direct question, are the higher judges far more compromised and therefore less willing to take on the establishment than the lower court judges?
No, I don't agree with that. There are judges and judges. There are some judges who may be compromised. A lot of them are not compromised. But in fact, I will say something to the opposite.
Yes.
Because lower courts, I know, being a chief justice of two states and a senior judge in one of the states, having been in 3 states, that many judges at the district judiciary level are not willing to grant bail, even in cases where they feel that they should grant bail, because they feel that if they grant bail, they will be hauled up by the High Court.
Right.
This is a very dangerous trend, and in one of the courts where I was Chief Justice, there were almost 500 disciplinary actions against judicial officers for granting bail. I mean, I questioned that because I said, if you are saying that a bail has been granted for extraneous reasons like bribe, etc., yes, please hold disciplinary inquiry. But on merits, you can't hold a disciplinary inquiry into that. So there is a fear amongst the district judges, and especially cases which grab the public eye, which are very
So are you saying what Dharmendra Rana did yesterday, Judge Dharmendra Rana did, was an exception, not the rule?
Yes, it's a very courageous judgment, an exceptional judgment. He's a very good judge. I followed his judgments earlier also in 2-3 cases. He's done very well. No, I'm not saying there are many judges like him in the country. It's not only he. Right. There are many judges like him. But unfortunately, there are some judges who are very scared of and will not.
Indira Jaising, in conclusion, do you believe that we need to relook at sedition laws and indeed the other laws you mentioned, NDPS, PMLA, UAPA, or do we just need to look at the way the criminal justice system is structured? As Justice Gupta says, if a judge gives bail, he's worried, will he be pulled up by the higher courts? Do you believe the problem is with the system or is it with the laws?
Rajdeep, earlier on in this program, you mentioned students, you mentioned, I would add to that, lawyers who appear on behalf of human rights activists. You mentioned intellectuals, you mentioned journalists. These are the new minorities of India. Who is the new minority of India? Those who dissent, okay? So I would like to say that the law of sedition has no place in a democracy. We do not sign an oath of allegiance to any government. We do not give away our conscience at the time when we cast a vote every 5 years, okay? We retain to ourselves the right to, let's say, give issue-based support, or, to agree or disagree with governments depending on the policy that they adopt at a given time. That's the first time. Therefore, the law of sedition simply has to go. In fact, if you believe it or not, but I did ask you whether you have challenged it. Second point I want to make is, do you know that amendments to the PMLA, Prevention of Money Laundering Act in India by this government have been introduced as money bills without any debate in the Rajya Sabha? There is a complete go-by given to the rule of law in this country. We have become masters at using law to defeat law, and we are living in a state of lawlessness. So yes, I agree with you. These laws have to go. Once they go, then judges' minds will be liberated, and they will not have the fear that Justice Deepak Gupta talked about. I'm in complete agreement with him. You cannot sanction a judge for giving bail. If you're going to sanction a judge for giving bail, you can call this the criminal injustice system.
Criminal injustice system. Let's liberate our minds, the minds of judges, the minds of government officials, the minds of police officers. Only then can we truly imbibe the spirit of that excellent judgment that was given yesterday in the Disha Ravi bail order. Thank you all very much for joining me on my top talking point this evening. Let me take a break at this point. When we return, I'm turning to the other big issue today.